Yes, Mr. Pilgerstorfer.
My Lords, thank you. I think I can be reasonably brief with the remainder of my reply. The next topic I wanted to turn to very briefly was the answer that Mr. De Mello addressed to you on this morning regarding the relevance of the friendly settlement documents that he showed you from the Strasbourg court, one example of which is at page 1005, and he asked the question during his submissions what the relevance of those documents are, and it might not surprise you to learn that my answer is none whatsoever. The reason is this is a formal record of the court settling litigation, doesn't involve any acceptance on the part of the government that the deport decision was unlawful, wrongly made, or in breach of Article 8. Indeed, it just simply records a settlement, as part of which you will see that a new decision was made by the government on the basis of the new circumstances then presented at the time that those documents were entered into. My learned friend says that he can rely on it on the basis of the reliance that I place on KO as being a factual precedent. Certainly I haven't suggested KO is a factual precedent before this court. No. I certainly didn't intend to do so before the Court of Appeal, although I appreciate that's how they understood it. My point in relation to KO is the nature of the reasoning exercise that was approved by the Supreme Court in KO is what is relevant and your lordships may refer to. That's all I need to say about that. Moving then to very compelling circumstances, rehabilitation and seriousness. I've accepted in my primary submissions in respect of rehabilitation that it is a relevant factor that can come into play. And as has been noted in Article 8 terms, derogation terms, Article 8.2 refers not only to public safety, but also to the prevention of disorder and crime, so therefore engages with deterrence considerations. I don't demur from the general consensus on the other side of the court that this might not be the case in which to conduct a detailed examination of the various dimensions of the public interest in deportation, that is, the distinctions between Lord Kerr and Lord Wilson's views in the Hesham Ali case. However, I do maintain that it is consistent with Article 8 for domestic authorities, including the courts, acting within the margin of appreciation to ascribe weight to factors that can come into the Article 8.2 assessment. And I've taken you to the Sanambar decision, page 920, paragraph 19, for your note. Here, the Court of Appeal and the Upper Tribunal both agree that generally this is a factor that's entitled not to great weight. And I say in general terms that's correct, albeit that I don't accept the criticism the Court of Appeal makes of the Upper Tribunal's observation in relation to credit. Read fairly, I say that the Upper Tribunal's views in terms of rehabilitation properly reflect its relative status, the weight that can be ascribed to it, given its relative status to the very compelling circumstances threshold. In terms of seriousness and rehabilitation together, I just wanted to make a few submissions in relation to the case that Mr. Pizzini produced and sent through. It's the Polly Gordon case, which you, I understand, my lords, have electronically. That is a case in which is an illustration of how the Upper Tribunal sitting in Edinburgh has interpreted the HARA decision in the Court of Appeal, which you're of course looking at.
I'm sorry, can I just check that I actually have this?
Okay, on an email, I think, this morning.
Yes, thank you.
Thank you, my lord. So in terms of what this is of course relevant in terms of what I've submitted were the constraints that the Court of Appeal in HA and RA placed on considering the seriousness of the offending. And I submit it demonstrates as a good example that the upper tribunal certainly understood HA to be putting those sort of constraints upon how seriousness should be considered. I've already made my submissions as to why that's illegitimate. But perhaps I can give you some paragraph references to this decision. In terms of sentence length, from paragraph 19, you will see that the first-tier tribunal dealt with a submission that HA was authority that sentence length was the definitive indicator of seriousness. And the first-tier tribunal had some difficulty with that and explains why that was so in various paragraphs from 21, 25 and 27. When one moves then to what the upper tribunal did in its assessment of the first-tier tribunal's decision, at paragraphs 32 to 35, the upper tribunal considered that the FTT fell into error by going beyond sentence length when assessing seriousness and holds in terms the length of the sentence as is the determinator of the seriousness of the offence. Moving on, though, I have to accept in paragraph 38, it goes on to leave the door open and says that it's not an absolute rule and the room is left for aggravating or mitigating factors in certain cases. But at paragraph 40 says that those circumstances will rarely arise. Now, I appreciate this case was fundamentally concerned with the effect of the guilty plea on the sentence length. Whether the first-tier tribunal was right to look at sentence length without the guilty plea being factored in. Now, of course, the actual sentence is what the sentence is after those considerations are given, and that's relevant to the categorisation in terms of deciding what test to apply. But as a matter of principle, it can't be wrong in my submission to take into account that sentence was arrived at after guilty plea credit was given when assessing the seriousness of the offending. That logically, in my submission, doesn't go to the seriousness of the underlying offence, and that's relevant when one gets to the very compelling circumstances element of the test. Another...
In the criminal sphere, the personal circumstances of an offender count for very little when you're setting what is an appropriate sentence. But it seems to be that personal circumstances are taken into account in this arena. Do you agree with that or not?
Well, my lord, I was coming on to that very point because the second important point that this upper tribunal makes at paragraph 40 is the risk of double counting when one focuses exclusively on, were one to focus exclusively on sentence length. Personal factors do come into the sentencing exercise in this jurisdiction. One sees in almost all sentencing guidelines that the Sentencing Council produces a list of potential personal circumstances that sentencing judges may have regard to when setting appropriate sentencing length. In my submission, it wouldn't be right to generalise and say that they can never have a significant effect upon sentence. Frequently one sees, for example, in pre-sentence reports where those are prepared, an assessment by the probation service as to what, in their view, the risk of further offending of different offence types might be. And that is frequently a factor in my submission that judges in the criminal sphere do have regard to when setting what might be the appropriate penalty and indeed the length of any custodial sentence. What the double counting point goes to, of course, is the risk that if ultimately when one's looking at the very compelling circumstances test, one is engaged in a balancing exercise, albeit calibrated by statute, of the Article 8.2 type. It's a proportionality exercise. You're looking at whether the circumstances can outweigh the public interest in deportation. If you've already taken into account, if you only take into account sentence length when looking at the strength of the public interest, and sentence has already been set on the basis giving credit for certain characteristics, you've lowered the public interest by simply looking at sentence length. It would then amount to double counting, is the point the upper tribunal rightly makes in the second point in paragraph 42, if you then put them on the other side of the scales as well at the stage of looking at the Article 8.2 question. So in my submission, the double counting point is a real and correct one that the upper tribunal makes here, and it has implications for, firstly, rehabilitation, for example. So to the extent that rehabilitation up to the point of sentencing, I of course accept that it can only be up to what's taken into account at the point of sentencing. Anything that happens afterwards is a different matter. But up to that point, a first-tier judge must, in my submission, be alive to the risk that anything that's put on the foreign criminals side of the scales has already been taken into account if they're only looking at sentence length. Yeah. So that's another reason why it would be wrong to shackle a view of seriousness.
Yeah. One can imagine, for example, two co-defendants who have been charged with the same offence because they did it together.
Yes.
And one of them pleads guilty, the other one goes to trial, and they receive different sentences because of that difference. But the seriousness of the offence would be identical in, yes, in the two cases.
Yes, precisely. So those are the observations I propose to make about Gordon and very compelling circumstances. Otherwise, you've got my primary submissions. Turning by way of conclusion, I simply have a few observations in relation to the disposal then of two of the three cases. In HA, some submissions were made about the status of the first-tier tribunal decision. And you were taken to paragraph 59 of the upper tribunal's decision on 397, where the upper tribunal said that it took into account parts of the first-tier tribunal decision. What that paragraph, properly understood, indicates is that the upper tribunal was taking into account the evidence, the paper evidence that was before the first-tier tribunal, and also those parts of the decision which recorded the oral evidence that had been before the first-tier tribunal. To that extent, I'm at one with my learned friend, but to the extent that any findings of fact or any analysis of the first-tier tribunal is relied upon, then that, in my submission, would be illegitimate, given that it was overturned. That's perhaps a small point, doesn't take us too far, but I thought it important to highlight. Then in terms of RA's case, a submission is made that the case should go further for reconsideration in any event, and that was primarily placed on the submission that the Secretary of State before this court doesn't challenge the conclusion that the Court of Appeal reached in respect to the go scenario. Now, were your lordships to be with me insofar as my challenge to the Court of Appeal's conclusion on the stay scenario, then the upper tribunal's conclusion on the stay scenario would prevail, i.e. Overall looked at exception 2, deportation would not have an unduly harsh effect. And if the court is then also with me in respect to the very compelling circumstances conclusion, then there's no reason in my submission for the case in any event to be remitted for reconsideration. That submission seems to be founded upon a wish to rerun that decision. If the upper tribunal's conclusions on unduly harsh on stay and very compelling circumstances are right on the basis of the decision, on the basis of the case as it was run before them, then it's not right to remit it in any event. Very finally, then, on the unduly harsh on the stay scenario, some submissions were made in respect of evidence. As previously submitted, the tribunal can only inquire and reason and respond to the evidence that's put before it. That evidential picture was extremely limited in RA. I invite you to exercise real care with submissions about evidence made to you today. And it's important to recall that before the Court of Appeal, the appeal that RA ran was not on the basis that fresh evidence should be considered. It was impugning the upper tribunal's decision for error of law on the basis of the limited evidence that it heard. My Lords, that concludes what I propose to say by way of reply. Unless I can assist any of your Lordships any further with any other residual matters, those are my submissions.
Thank you very much indeed. Well, we're most grateful to all counsel for their assistance, and also to those sitting behind them who no doubt have contributed a great deal as well. We'll now take time to consider the submissions, and we'll let you have our decision in due course.
Thank you very much.